And Michael, you just let me know when you're ready to start the seminar, when you're going to let everyone in, okay?
Sure thing. Yeah, I was just about to say I will let people in right now. There's 16 people in the waiting.
Okay. Good evening, everyone, and welcome. Thank you for coming this evening. For those of you who have just joined us, we're glad to have you. And we're going to give folks about 1 more minute to log in and join us. So please put your devices on mute because we do have a relatively large crowd tonight. So we'll begin in about 1 minute or so. All right, well, welcome everyone. Thank you so much for joining us here this evening. My name is Kendra Bowen, and I'm an estate planning attorney with the Housing and Economic Rights Advocates. This seminar this evening about estate planning is sponsored by Habitat for Humanity. So we want to really thank Sonia and Afra for all of their efforts here. And we want to thank the crowd out there for joining us this evening. We will be covering a lot of topics related to estate planning this evening. I will have questions at the very end. So if you will please hold your questions until the end, I will try to get to all of your questions. The one thing I would recommend you do with respect to your questions, though, is to not disclose personal detailed family information because this is a public forum. So once again, I'm Kendra Bowen, very pleased to be here this evening. I'm from HERA, the Housing and Economic Rights Advocates. HERA is a group of lawyers. We're a nonprofit law firm, a legal service, and we provide legal services to our clients, which mostly concern home ownership, foreclosure prevention, estate planning, some loan situations. So we do a breadth of work. Tonight, though, we are going to cover estate planning because most of you who are joining us here are homeowners, and particularly homeowners need to have estate planning done. So today we're going to discuss the what, who, when, why, and where of estate planning. Next slide, please. So one common barrier to estate planning is some people, and you might have relatives who are in this boat, they say, you know, I anticipate renting. I don't think I will own a home in California, therefore I don't need estate planning. Well, that is false, and hopefully you will learn that by the end of this evening. Hopefully you'll walk away realizing that everyone who is an adult needs some form of estate planning. Next slide. Another barrier to people having their estate planning done and completed is that people realize that the state of California has a mechanism to distribute property. If it's a single parent who passes away after a long, expensive process, typically that estate will go to the children of that single parent. However, If an adult wants to, for whatever their reason is, make sure that their estate only goes to 2 of their kids, that can absolutely happen as long as that client places all of their intentions and desires in properly executed estate planning documents. So while there is a default mechanism in California, we much rather have you folks decide where you would want your estate to go when you pass away one day. Next slide. Some people, let's say they were going on a trip or they had surgery and they completed a will. They might think, aha, I have all of my estate planning completed. Well, I think we will learn together tonight that a will typically is not enough, especially if you're a homeowner. Plus, a will does not cover handling the aging process in a graceful manner. So we want you folks to make sure that the last stages in life proceed according to your terms as opposed to someone else's terms. And there are some estate planning documents which can help make sure that that does take place. So a will typically is not enough. And next slide. And then we have, and probably most of us have heard stories where people say, you know, my children understand what's supposed to happen. My family understands the deal among all of us, so I don't have to put it in writing because my children will do the right thing. Well, sometimes children can't avoid probate, and we will touch upon that in more detail, and that's an expensive, stressful process. Plus, some of us have probably heard of families where a parent passes away and we see or hear about those horns coming up from the children. We hear about the children's spouses becoming involved, which muddies the water. So we much rather, once again, have all of you complete estate planning so that you will help keep the family peace down the road. Next slide, please. So we do estate planning now while we're still with it and feeling good to address future needs. If we wait until we're incapacitated, that would be the time when we need some documents. We've missed the window to complete the documents. So we prepare documents now so that they are there in the event of incapacitation, and they are there when we pass away one day. Next slide, please. So these are the 2 groups of estate planning documents that most of us need as adults. We have documents on the left in blue. Those are the documents that typically govern how our lives will progress when we're incapacitated. Okay, we have a durable power of attorney for financial purposes, and we have an advanced healthcare directive in blue. We also have a trust, which is always changeable, amendable, revocable in blue, but we're going to touch upon that document a little bit more. Now you'll notice when people pass away, the power of attorney disappears and the advanced healthcare directive disappears, because when people pass away, those 2 documents become void, and the only documents that really have effect would be the trust, which is now unchangeable because you're no longer here to change the terms of it, and a will. Okay, so think of it in terms of 2 groups of estate planning documents and 2 groups of issues. The documents in blue are important while we're alive, but let's say incapacitated, and then the documents in yellow govern what will happen to our assets when we pass away, who would be the guardian of minor children and any dependent adults. We're going to touch upon both of these important groups of documents this evening. Next slide, please. So once again, we prepare now, even though we don't need these documents yet, to address our future needs. Now we pick someone to manage our assets if we become incapacitated, to advocate for us in a medical setting if physicians cannot appropriately speak with us. We prepare the documents now to pass on our assets and determine guardianships when we pass away. Next slide. So we're going to discuss the larger group of estate planning documents, which governs what happens when we pass away and what do we need to have done to make sure that it's an easy, seamless process. So in general, in California, we're trying to avoid the probate process. And probate in California is expensive. Typically, families have to hire a lawyer. It takes a long time, at least a year and a day, and it's a very impersonal process. So we can avoid putting our loved ones through that probate process by doing a couple of things. we can, especially since most of you are homeowners, create a revocable trust and put assets in the trust. You still own it, you can sell it and spend the money, and you are not accountable to anyone for your actions other than yourself. And then another way to avoid probate in California is to place beneficiaries on assets. So we can, for instance, on life insurance and retirement accounts, put a beneficiary on those types of assets. Even with some bank accounts, we can, or investment accounts, we can put beneficiaries on it. That could be a fine tool to avoid probate. However, creating a revocable trust is, I would say, the preferred way to distribute a house or any real property when you pass away. So we're going to dive a little bit more closely into creating a revocable trust and what that means to you or for you. Next slide, please. So a trust is just a document that a lawyer would prepare for you or for you and your spouse if you're married, and it's just a structure that will contain some of your assets. So for instance, when we have a client come to us, they're a homeowner, obviously subject to a mortgage, we all have mortgages, but they want to protect their family from the probate process, and they want to make sure that distribution of assets upon their death goes smoothly. So we'll talk about just creating a revocable trust. And the important part of a trust essentially says where you want your assets to go when you pass away, and you would indicate that in your trust. The other big point of having a trust is choosing who you think would be the best person to carry out that task one day when you're no longer here. So if you're a single parent and you have 3 children and your middle child is extremely responsible and is a get it done kind of person, you might want that person to be the person who would one day carry this out on your behalf. Keep in mind though, while you're alive, and especially while you're with it and have capacity, you are the only one who gets to control your assets. You get to sell your assets, purchase new assets, put them in the name of your trust. You get to disinherit people in your trust. You can change your mind a couple years later. You can sell everything and move anywhere you want. And once again, you aren't accountable to anyone other than yourself. So having a trust means that you completely own your assets, and you're the only one, or with a married couple, the only two who can control those assets during your lifetimes. In a trust, of course, you'll identify your family members. Trust can be called all kinds of different things, such as a trust agreement or a declaration of trust. It really doesn't matter what it's called. It can be called the ABC trust. The main thing is that you have a lawyer create the trust. You have a lawyer help you put your home into that trust, and typically they do that. There's no property tax reassessment or anything like that, because the government still views you as completely owning your home when you put it in the trust. So that's good news there. Typically, you'll put some bank accounts into the trust too. That's a very safe way to make sure that those are distributed according to the terms of your trust. So once again, it's a legal document that lawyers create. You indicate where your assets are going to go, who will be in charge of that process. And if you do have minor children or dependent adults, typically in a trust, you will indicate who their guardian would be, okay? Now, for those, and probably none of you are in this boat, but you might know of people who don't own a home. Maybe you have parents or siblings. They can distribute assets and choose guardians through a basic will, and that is sometimes okay for people who don't own homes in this state. Okay, so there's nothing terribly wrong with a will as long as folks have under the threshold of probate, which is currently $184,500. For those of you who do have homes, you most likely have an asset worth quite a bit, and you need to seriously think about having an attorney create a trust for you and then funding the trust with your main assets. Next slide, please, Michael. So let's look at the difference of what would take place when someone passes away if they were a homeowner and if they had a living trust. and put their home in the trust, and that's reflected on the left side of the page, versus someone who had a home and only had a will or didn't have a will, and their estate was subject to probate. So let's look at the left-hand side first, the preferred way. Someone who created a trust, put their home and other assets in the trust, and that eliminated the need for probate. So there's no probate. And one other benefit of creating a trust is that the trust is private. In fact, even when you pass away, that trust is not filed. It is a private record. It is not filed at the probate court typically. No one is going to know where your assets went, even when you're no longer here typically. Also, if there is just a trust administration when you pass away, there are no statutorily guaranteed fees to the successor trustee or to their attorney if an attorney is needed. Sometimes when people pass away and they have all of their assets in a trust, then the personal representative or successor trustee doesn't even need to engage an attorney. So that once again saves your family money. The successor trustee completes all of the trust administration tasks without court supervision or approval, which once again saves a family money. Assets in the trust are not subject to estate recovery in case any medical benefits were paid. As long as those assets are not subject to probate, they typically will not be subject to estate recovery by the state. And it just takes a shorter period of time and less money to go through a trust administration. Let's look at the right-hand side of the page. Someone who had a will or didn't have a will, and let's say owned a house and owed assets over $184,500, which is the current probate threshold. So if they passed away, probate would be required. And if they had a will, that will would be filed with the probate court. Anyone could look up that will and see where your assets are going to go. If there was no will, someone can still look up in the probate records, perhaps after probate is finished, and see what happened to those assets and where they went. Most of us would prefer to keep our family matters private. With probate, there is statutory compensation with probate, which means that the attorney is going to receive quite a hefty fee, and the personal representative appointed by the court will be receiving quite a hefty fee as well. The executor or the personal representative in that situation where there is a probate completes tasks only under court approval. They need to go back to court periodically and garner approval for various steps in the process. That's why it costs quite a bit of money. That's why personal representatives and executors going through probate typically need to hire an attorney. Assets subject to probate will be subject to estate recovery in case any medical benefits were paid. And the probate process just takes a longer period of time and costs a lot of money as opposed to the trust administration process. Next slide, please. Touching briefly upon a will, as I mentioned earlier, for those who do not anticipate owning real property in California, and who still want to make sure that the contents of their apartment go to family members or go to whomever. They may want to make sure that an account goes to whomever, as long as that amount, which will be distributed when they pass away, is under $184,500, the will probably will not be subject to probate. If someone creates a will, though, and let's say they inherit a house or some other asset and then they pass away, a probate would be needed. So if you do have family members who are not homeowners, please advise them to speak with counsel if they're interested in having estate planning done, even if they think they just need a will. Next slide, please. All right, so here's an illustration. We're looking at some round numbers. So on the left-hand side of the page, we once again have the trust administration side. So someone who owned a home and accounts that added up to $1 million, but they had a trust and they had retitled those accounts in a very simple manner to their trust. So all of those accounts and real estate holdings totaled $1 million. They passed away. They had a trust. Let's say there's a loan against that home of $300,000. So the net value there would be $700,000. We're looking again at the left-hand side of the page, someone who had a trust and who has passed away, and that trust will distribute property to their family. Let's say the house needed to be fixed up for sale once the parent passed away. So $20,000 was shelled out to contractors and painters to clear things out and make a home as presentable as possible to render the highest bid upon going to the market. So the house was sold and there's a balance of $680,000 there. That can be distributed to family members because everything was in a trust. So let's compare that to the probate administration side. We still have the same person who owned assets that total $1 million. They had the same loan amount of $300,000 against that home. And so they had a net value there of $700,000. Let's say once again that the cost of getting the home ready for sale, clearing it out was $20,000. So against the net value of $700,000, we take up the $20,000 and we have a balance there of $680,000. However, because this estate was subject to probate, there's a statutory fee that will go to the attorney handling the probate. And then there's also a statutory fee which will go to the attorney that the personal representative hires. So the fee for an estate worth $1 million is $23,000 to the personal representative, and then another $23,000 to the attorney who was helping the personal representative or the executor. The probate court looks at the estate being worth $1 million. The probate court does not look at the estate being worth only $700,000 because probate courts do not factor in loans against assets. So that's where people can sometimes think, oh gosh, you know, I own $1 million home, but my loan against it is $900,000. Therefore, my family, upon my passing, would not need to go through probate. That is incorrect. The court does not look at the loan against the property. So we much rather, once again, have you complete a trust or utilize some of the other tools to avoid the probate process here in California. Next slide, please. We're going to look at one more example here, and all of you can feel free to put an answer in the chat if you feel like taking a guess at the answer here. So we have Pamela, and does her estate need to go through the probate proceeding? She passed away and her assets are as follows. She had a home worth $300,000 and her deed, her grant deed states that she owns the home, Pamela, trustee of the Pamela Trust. She had 2 retirement accounts and she indicated that her relative Ben was a beneficiary. She also has life insurance and she indicated that her mom was the first named beneficiary. However, Pamela indicated a younger beneficiary to be the secondary beneficiary. Pamela's mother, Stella, passed away before Pamela, but Pamela's younger brother, Leo, was still alive when Pamela passed. And then Pamela also had a relatively small checking and savings account worth $2,000, and she indicated that Tommy was the beneficiary on it. So in Pamela's situation upon her passing, do you think that a probate proceeding was needed? And feel free to put your answers in the chat. Any takers? Okay, well, Pamela did everything correctly. Next slide, please. She had her home in a trust as indicated by the fact that her deed reflects that she owns the home, trustee of her trust. She had a living beneficiary on her retirement account. She had a living beneficiary on her life insurance policy. She even had a living beneficiary on her bank account. So Pamela did everything correctly. The trust will remain private and assets will be distributed to the people indicated here. Okay, so let's look at the next example. We have Alex, and he had assets similar to Pamela's. So he passed away, and he also had, next line down, perfect. He had a home worth $300,000, and his deed stated that he owned the property as Alex, an unmarried man, perfect, Michael. He had 2 retirement accounts, but he forgot to complete his beneficiary designation page, unfortunately, before his passing. He had life insurance And while he did name his father, Sean, to be the initial beneficiary, he forgot to name a second or younger beneficiary. And unfortunately, Alex's father died before Alex. And then he had a couple of bank accounts, and he was very ambiguous and just stated, my girlfriend is the beneficiary on my bank accounts. Do we think in Alex's situation, there needed to be a probate proceeding? Any takers? Next slide. Alex didn't do anything correctly. Unfortunately, his home, he just owned in his name. He didn't place it in a trust. He did not have living beneficiaries on his retirement account. He did not have a living beneficiary on his life insurance. He didn't have a living beneficiary on his bank account. So the whole amount of, I think it's 517,000, I don't know what the total is here. Oh, yes. Yes, 517,000, unfortunately, was subject to probate. So let's not be Alex. Next slide, please. There is another tool that can sometimes be helpful to homeowners in California, and it's called a transfer on death deed. Next slide, please. So once in a while, we have someone who wants to have something done relatively quickly to avoid probate for peace of mind. Perhaps they have surgery coming up or some travel coming up. So while the preferred mechanism for transferring assets upon death, especially homes, is to have an attorney create a trust and put your home into the trust. As you continue on through life, you might sell that home and purchase a new one in the trust. It's meant to grow with you as you proceed through life. A transfer on death deed can help avoid probate as well. So a transfer on death deed is a 2 to 3 page document where you can put beneficiaries on this deed. And if you were to pass away, your property would be distributed to the living beneficiaries you have placed on this transfer on death deed. So let's say you have 3 children and you completed a transfer on death deed. Let's say, and we have to be horrible pessimists here, so let's say you are with one of your kids and the 2 of you passed away together. Well, by virtue of the transfer on death deed, your property would go to your 2 living children. Sometimes that is not what you would want to have happen. So because let's say your 3rd child had kids and you wanted that 1/3 that deceased child was going to receive to be distributed to their children, your grandchildren from that deceased child. That can't happen with the transfer on death deed. So it has limited use, but sometimes it can be an effective tool. And especially if you need something done quickly, and then if you're going on a vacation and want to then come back a month later and have an attorney do a trust. This can be done relatively quickly. Next slide, please. The main thing to keep in mind with the transfer on death deed is, as you can see here, it is a notarized document. So while you can complete it almost on your own, you don't sign it until you're in front of a notary. It deals with real estate, and everything dealing with real estate needs to be notarized. Also, after it's notarized, it must be filed with the appropriate county recorder within 60 days of its notarization. So keep that in mind. If you change your mind about the beneficiaries on this deed, you have to actively revoke this deed with the county. So those are just a couple caveats about this tool, but once again, it can be an effective tool at times to distribute property at your passing. All right, next slide. So in a nutshell, we have covered the estate planning documents, which are crucially important to cover what is going to take place when you pass away. We discussed creating a trust if you're a homeowner, having that attorney put your home into your trust. It's no barrier to selling a home. If you sell your home and thereafter purchase a new one, it's fine. You just sell it on behalf of your trust and purchase the new one on behalf of your trust so that your trust always stays funded as you go through life and acquire new things. We've also discussed putting beneficiaries on assets. That it can be an effective tool to distribute assets at your passing. If you have retirement accounts or life insurance, you can simply go to those institutions or companies, ask for your beneficiary designation page, look to see who you have assigned to receive that asset at your passing. If you don't like what you've decided upon, or if you don't have that contingent second choice, you just merely complete another beneficiary designation page and make sure to return it to that company. So the two most common tools to avoid probate are creating a trust and putting assets into it, and putting beneficiaries on other assets. All right, so now we're at the second part of estate planning, which covers what happens, or what documents do we need while we're alive to make sure that those later stages in life go in the most graceful way possible and according to our terms. So we're going to look at the durable power of attorney for financial purposes and an advanced healthcare directive. Next slide, please. And keep in mind, these documents don't have anything to do with passing on assets or guardianship of any or anything like that, because these documents are only effective while you're alive. Keep in mind, even if you've created a trust and put your home into a trust, no one is allowed to distribute any of your property, even if you're incapacitated, to anyone other than you, yourself, until you have passed away, okay? So these documents just govern how your life is going to take place and who you trust to be part of that process for you if you're unable to do that yourself. So once again, you're planning for incapacity now, and you're going to choose people that you trust to do the best for you, okay? They have a fiduciary duty for you when their skills are needed. So when you're incapacitated, you want to make sure that on your power of attorney for financial purposes, you have someone that you wholeheartedly trust to use your money and your assets to take good care of you. They are your fiduciary. They can't distribute to anyone other than you until you have passed away. Likewise, with an advanced healthcare directive, while doctors have a duty to try to communicate with you and explain things to you, if they feel that they cannot effectively do that due to a declining medical condition or medication or something like that, they will have your authority to speak with someone that you have indicated is your agent on your advanced healthcare directive. Doctors can even share information that they might need to make good decisions for you. So you want someone on that advanced healthcare directive to be someone you, once again, wholeheartedly trust to advocate for you in that medical setting. Something to keep in mind is while you're choosing people to act as your agents on these various documents, your power of attorney, your healthcare directive, you want to very honestly assess the strengths and weaknesses of these people. You might have an adult child who is great at filing their taxes on time and paying their bills on time. So that might be a really good choice for your power of attorney and even executor of your will and successor trustee of your trust. However, if this child is someone who walks into a hospital room and looks at, their grandmother and she has an IV and gets queasy, that's probably not a good choice for your advanced healthcare directive. For the advanced healthcare directive, you want someone who can be fine in that medical setting in a hospital, making sure that physicians are doing what you would want them to do and are not doing things that you would not want them to do to you. So you need someone strong in that medical setting who has a stomach for those types of things. It is okay to have different choices for the healthcare agents and fiduciaries as compared to the fiduciary on the power of attorney and the other financial documents, which would be like your trust and the successor trustee. A healthcare agent can advocate for you in many different ways, and we encourage you to put preferences down in your advanced healthcare directive, such as if you were in a coma for a while or you had dementia, do you want artificial nutrition and hydration, or do you not? If you think about it now, it really helps your agent advocate for what you would want and how you would like that last stage of your life to be. Likewise, you can state in your advanced healthcare directive whether you are fine going to a senior living facility or a memory care place, or if your preference would be to stay in your home and have in-home care. The more detailed you can be in these documents, helps the agent that you have chosen advocate for you. For instance, they can show a physician, look at this part of the healthcare directive my mom completed. She does not want what you are proposing to do. So detail is very good in these documents. Next slide, please. While I said that you can include a lot of detail in your advanced healthcare directive, you can include some detail in your durable power of attorney for financial purposes as well. You can make the authority of your fiduciary, of your chosen person to act on your behalf one day quite limited or quite broad. You can allow them to act on your behalf even before you're incapacitated, if that's what you would want. Many times people want it to be more of a springing power of attorney, which requires that the power of attorney is accompanied by a letter from one or two of your doctors stating that you are incapacitated in order to be effective. So that's called a springing power of attorney. So you can refine these documents according to your needs and your comfort level with your circle. You would explain your preferences to any attorney that you worked with. Next slide, please. With both of these documents, durable power of attorney for financial purposes and advanced healthcare directive, it's good to have a first choice, and it's also good to have a second choice. And if you can, to have a third choice. You want to choose people who are assertive. It's best to have people consecutive rather than forcing, let's say, two people to act together. If you think about it with your advanced healthcare directive, if you named your two kids equally on that and they had different perspectives on your medical care or what they thought you needed, if they couldn't come to an agreement, hours could tick on, days could tick on. So it's best to go with your gut and choose the person who you think is most predisposed to do a good job for you. So we like people to make a first choice and then a second choice and a third choice, as long as you wholeheartedly trust all of those people. If you only have one person that you wholeheartedly trust, only put that one person down. You can choose people, adults, who really live anywhere. I would say proximity, though, is important for the advanced healthcare directive, because if you think about it, if you're in a hospital locally and you're down and out and your eldest child is the agent on your power of attorney, it's good if they can be here within a couple of hours to assess what's going on with their own eyes and speak with the doctors and the nurses face to face, and really, assess your condition by being present with you. So that is ideal. But if all of your relatives live back east, hey, if that's your circle, then you just need to go with the person who is most predisposed and maybe someone who's quite tech savvy. As I indicated, they need to be an adult. And if there is a life-changing event in your life, such as marriage or divorce, it's good to update your choices. I've had clients who are married, and of course they name their spouse as their first choice, but then they get divorced and they forget to change those documents. So it's really important to revisit your choices on an advanced healthcare directive, a power of attorney, and then of course, even in your trust and will. We suggest that you review your choices after the first of the year, New Year's. You maybe just give all of your estate planning documents a once over to ensure that you like your choices. If possible, depending on your family dynamics, it's a good idea to have an ongoing discussion, not necessarily about your trust and will. You have no duty to explain to your kids or loved ones where your assets are going to go if you pass away and what the percentages are going to be. However, if you do have loved ones or children who are the agents on your healthcare directive, it's good if you are able to explain your perspectives on, end of life with them, so that they can do the best job possible if they need to act as your agent in that regard one day. Next slide, please. We prepare the durable power of attorney and advanced healthcare directive to avoid a conservatorship hearing down the road. So for people who have not created an advanced healthcare directive where they have indicated who they want to advocate for them if they're incapacitated, For those who have not completed a durable power of attorney and indicated who they want to take over their finances, if they're advocated, if they're incapacitated, there is a conservatorship hearing and proceeding available for families. So what would happen is if a parent becomes incapacitated, there is no power of attorney or advanced healthcare directive, family is notified, family has the ability to, each member, hire a lawyer to present to the court why they feel they are the best choice for you to either handle your finances or handle your health care. A judge will try to do the very best they can in a morning hearing, but we trust our clients. We much rather have you decide who would be appropriate to either handle your finances or your medical care if you are not able to do so yourself. So once again, that's why we highly encourage you to at least get a power of attorney and healthcare directive done while you're feeling good and before you need it. I will say with respect to the advanced healthcare directive, if some of you are with some of the bigger institutions around here, Kaiser, Sutter, oftentimes they have a blank healthcare directive that they are more than happy to give to you the next time you visit your physician or physician's office. I think you can even go onto the portal and download a blank one or print it out and fill it out with all of your desires and goals and the names of the people that you trust for this potential role of responsibility. So as long as you are able to indicate what is right for you in that document and either sign it with the formalities requested, which would be a notary or 2 disinterested witnesses, and if you turn that back in, that is okay. A lawyer does not need to prepare your healthcare directive for you as long as you do it yourself and you're able to express what you want for yourself during especially the later stages in life. But if you complete the healthcare directive, make sure to complete it, which means sign it in front of a notary or 2 disinterested witnesses and turn it back into your medical facility so that if there is an accident or emergency surgery that needs to take place, there is not a scramble and the physicians would know who to contact if they needed authority to do something or withhold some type of treatment that you don't want. Next slide, please. A couple of additional documents relating to healthcare would be the POST and the DNR. Very important caveat here is these 2 additional documents do not take the place of a well-drafted advanced healthcare directive. These are very brief forms that typically people in the later stages in life will complete when they are, still with it, of course. It could be a physician order for life-sustaining treatment that you can complete, typically after talking with your doctor and even completing it with your doctor. And then the DNR, or the pre-hospital do not resuscitate form, is again another document where you would indicate that you did not want resuscitative measures. Let's say you chose to go under surgery, but if things went awry, you did not want certain things done to you. That is completely within your right, but we would highly advise that you sign off on a DNR if that was your preference. And typically this is signed and completed with your document. So once again, the scope of these 2 documents is very limited. An advanced healthcare directive is many pages and it covers things like Alzheimer's and dementia. Those of us who know people who have had either of those diseases know that oftentimes they are not receiving any kind of medical treatment, but they have dementia. So there are certain things that you might not want for yourself if you have dementia and your quality of life is not good. So an advanced healthcare directive will cover situations where you're not even receiving medical treatment to make sure that your later stages in your life are according to your terms. Next slide, please. This is what a POST looks like, bright pink to garner the attention of maybe emergency personnel who are called to a senior living facility. Next slide, please. And then this is the DNR form. Again, it's typically completed with a physician. So it's fine to add these onto your advanced healthcare directive. Just please don't think that just completing this forms is a healthcare directive. Again, if you're with one of these bigger providers around here, ask that provider for their advanced or their healthcare workbook and complete it and try to turn it in if you can. That would be a DIY thing that folks can do on their own. Next slide, please. So once again, the two groups of estate planning documents are shown on the screen. We have the documents in blue, which everyone, or the durable power of attorney for financial purposes and the advanced healthcare directive are documents that anyone over the age of 18 who doesn't have a disability, because there are different stages for that, or different ways to take care of that. Typically, everyone over the age of 18 needs a durable power of attorney or advanced healthcare directive, because anyone over the age of 18 is a legal adult. Guardianship rules no longer apply typically, and they need to decide for themselves who should be in charge of their finances if they are incapacitated, and who should be their healthcare advocate if they're incapacitated. The trust is something that we homeowners should create with an attorney and pop our property into the trust. And when we pass or down the road, if we should sell that property and purchase a new one, we're going to put the new property in the trust. When we pass away, the trust becomes unchangeable, because the only person who was able to change the trust was us. Okay, it's all ours while we're alive. And even when we're incapacitated, no one can change the terms of the trust. When we die, the trust becomes irrevocable. No one can change it. But the person you have chosen to be your successor trustee in the trust does what you've taken the time to say in the trust. They gather the assets, they protect the assets, they will pay final bills, and then they will eventually distribute assets according to your wishes that you have expressed in your trust when you were alive and with it. And then the only other document that's effective when people pass away would be a will. And for those who have a trust, they typically have what's called a pour-over will. I don't have to become too detailed about that. And then for those who are under that probate threshold of $184,500 and who do not anticipate being homeowners, they can distribute the contents of the apartment through a will, okay? And both the trust and the will can determine the guardians of any minor children. Next slide, please. So if any of you decide to proceed with estate planning, you will schedule an appointment. If you are a married couple, it's really important that your spouse is on board with this and that your spouse participates. So make sure that you schedule an appointment when both of you can speak with an attorney. You'll have a meeting. It could be virtual, on the phone, or in person. The attorney will get to know you. Eventually, they will probably give you some kind of a workbook to complete to learn about your family structure, to obtain your choices about your choices for successor trustee, fiduciaries for the power of attorney, fiduciary for your healthcare directive. The one thing you do, or two things you do not need to provide in any of this paperwork are going to be Social Security numbers, that is not needed, and account numbers. You do not need to provide any account numbers. And while an attorney will want to have a general idea of what you have so that they can make sure to put your home into your trust and tell you to put beneficiaries on a retirement account, they certainly do not need the account numbers or exact amounts in your accounts themselves. So the attorney will review the choices that you send back to them in writing about who you want to be a medical agent and a financial agent for you, guardians of your kids. This attorney will be preparing drafts for you, draft documents. They will review those with you in some way. You can make changes to your drafts to make sure that they are accurately reflecting what you want to have happen one day, to make sure that you have people in control that you wholeheartedly trust. You'll review those choices. If the drafts fit what you would want to eventually have happen, then the attorney will arrange for you to sign them with a notary and witnesses. All of these documents need to be signed typically with a notary and or witnesses. The day that you sign it, they're effective. And the attorney will take those documents and scan them and give you your originals back typically file your new deed with your county recorder because it's really important that they know that you own your home in your trust. Once again, if everything's done appropriately, there is no reassessment of property taxes, and your estate planning documents are in effect. You can change your mind on any of these documents as long as you have legal capacity. So you have your documents, they meet your needs now into the near future, but just know that if there's a change in your life or a change in your family dynamics, or if you have a falling out with someone that you've chosen in any of your documents, you can certainly follow up with that attorney a year, 2 years, 10 years later, and do amended documents. So keep that in mind. You can amend your documents until you no longer have capacity. And then, like I mentioned earlier, it's very important to review your choices, especially if there is a life-changing event in your life. Next slide, please. These are just a couple of people who regrettably did not revisit their estate planning documents after they had a change in circumstances. So we all remember Heath Ledger. He did prepare some estate planning documents, and then he later had a child, and he never updated his estate documents to provide for that child. So there was a lot of litigation in his family, unfortunately. Barry White also, he had been married and he had been separated from his spouse for a very long time and had a partner who he'd been with for a very long time as well. But he never changed his estate planning documents. So when he passed away, there was a lot of litigation between the estranged spouse and the new partner. So once again, this just gets to the point that we really want you to revisit your documents. Even if you can't every year, I would say every couple of years or every 5 years at a minimum. Next slide, please. This is our information. Again, we have an estate planning legal team who drafts all of these documents. We charge on a sliding scale. So if any of you do want to schedule with our team, you can take down our phone number. It's extension 300. If no one answers the phone at the time that you reach out to us, feel free to leave a message and one of our intake people will reach back out to you and obtain some preliminary information and then set up an intake call with one of the estate planning attorneys on our team. Likewise, you can email us and we will do the same thing, okay? So I can open it up to questions about any of these topics. And Michael, you can let people in. I think people are not necessarily placing their questions in the chat, but raising their hands. So you can click on someone and you can
Certainly,
welcome you.
certainly.
Sure, no
Yeah, we
problem.
have a few questions coming in through the question and answer feature.
Okay.
First one, talking about what does it mean by funding your trust?
Good question. So people hear about trust funds and trust fund people. That really has nothing to do with what we're talking about. We're just talking about you're going to create a trust, and funding your trust means putting most of your assets, non-retirement assets, retitling them to your own trust. So you don't have to have a lot of money or anything like that. It's just whatever you happen to have at the present time should be retitled to the trust. So in the instance of people who own real property, your attorney who would create a trust would prepare a new 1 to 2 page deed where you would convey your property to yourself. And I know it sounds odd, but convey to yourself your own property as trustee of your trust. That is funding the trust. Likewise, if you have some stock investment account and you currently own it in your own name and you had an attorney create a trust, you would take that trust at some point or an abbreviated version of the trust, go to that institution and say, I have a trust. I want to transfer my account with you to my trust. And they will prepare retitling documents. You can do this at your bank also. And you will still own all of your accounts. So just own them slightly differently as trustee of your trust. So that's what's meant by funding a trust. It doesn't mean that someone has to be wealthy or anything like that. When we hear about trust funds, that's usually someone who set aside money for someone to live on during the course of their life. And that's kind of a different animal.
Thanks, Kendra. Next question. What is the difference between a trust and an estate?
Oh, good question. A trust is a legal document that a lawyer creates where you're going to put your intentions in there. Where is everything going to go when I die? Who is going to be in charge of that process? And who will be the guardians of dependent adults or minor children? An estate is just whatever assets are there when someone passes away. So if someone doesn't have a trust, they can have an estate. Someone can have a trust and they can have an estate. We want an estate to not be subject to probate. That's the main thing. So you can have an estate. That's a good thing. It means you have something, but we want you to either create a trust and put your stuff in that trust so that your estate would not be subject to probate, or put beneficiaries on your assets. So if you're someone who has life insurance and retirement and those are your main assets, you can put beneficiaries on that. And once again, that will prevent your estate from being subject to the probate proceeding that we have here, which takes a long time and is expensive, and we want to avoid it.
Another question here, wondering what is the charge to assist with the planning of a trust?
Sure. So the way we charge at HERA is based on gross income from last year. So we need some kind of proof of income to look at where you fall on our chart with household size and income. Private practice, I would say, to do all of these estate planning documents, if you have one home and the attorney needs to put the home in the trust, is around here in the Bay Area between $3,000 and $5,000 for a power of attorney, healthcare directive, HIPAA, pour over will, trust, grant deed, all of that, which are all the pieces and parts to a complete estate plan typically. I would say HERA in general is a third to a half. If we have very, very low income people, they can have it done oftentimes for just a couple of $100s. So anyway, so that's how we work. But in general, private practice, it's usually several $1,000s.
Just really quickly, someone who was not here from the beginning, but again, is it better to make a trust than a will? And where would we go to make one?
Yeah. So if you are a homeowner, or if you otherwise own assets that exceed $184,500, when you pass away, your estate could be subject to probate. And we want to avoid probate. So that's when you need to consider not just doing a will, but having an attorney do a trust for you. So if you are in that category, it's a good idea to talk to an attorney about, what the risk is there. You can call our office. We're a law firm. We're a nonprofit law firm. We charge for estate planning documents that we create, but it's on a sliding scale. So feel free to contact our office or any other estate planning law firm in your area.
Couple of questions here, which might be a little bit outside the scope of what we're talking about. Is a living trust done differently if a home is a Habitat for Humanity home? Any restrictions we have with Habitat for our property after we die?
Any of those restrictions we can write into the trust. So if Habitat, they want certain language in there, you let them know that you are doing this with us. And if they want any caveats in the distribution, then we put them in there. So Habitat wants all of you to avoid probate one day, and probably wants you to do your estate planning in some form or fashion, at least the power of attorney and healthcare directive. But again, any particular language they would want in there in your particular situation, we can add in there.
Last question here. My mother created a living trust, but when we submitted it to Sunnyvale County, we were informed there is some red tape involved. County staff seemed unsure about which agreement came first, Habitat for Humanity or the city of Sunnyvale. Could you please help us understand what this means and advise us on next steps?
It's very hard because I'm not looking at any documents in front of me. And also, I'm not privy to the title or any encumbrances against that property. So, Habitat might be there somewhere in the title search, any restrictions or encumbrances they would have. If there was a tax lien, the city might get involved. So I can't give an opinion on that because I'm not looking at anything here. Any other questions about the healthcare directive or power of attorney, probate? Go
One
ahead.
more question here.
Mhm.
Asking what is the tax implication on a trust? Do we need a tax ID?
Very good question. So when you create the trust is you. So you don't need a separate tax ID number for it as long as you're alive, because the trust is you. So once a lawyer creates that trust, and let's say you're going to go to your bank and put your bank account into your trust or your credit union, you have a nice chunk of change there. That institution is going to ask for the name of your trust, and they will ask for the tax ID number for the trust. But that tax ID number is your Social Security number. The process is very similar to when you initially went to that institution, opened up your own bank account. They wanted your Social Security number because that is, the ID number that they use to make sure that you are who you are, et cetera. Well, that is still the tax ID number when you have this type of trust, because with this type of trust, you own all your assets. You are free to sell them, to spend them. There are no restrictions on what you can do. So I will say, when people pass away, then the successor trustee does obtain a new tax ID number, but that's because the principal, the person who created the trust, has passed away. So their Social Security number can no longer be used. But it's not a big deal to obtain that tax ID number at the time of death when someone actually passes away. And there are no other tax implications by, creating a trust. You are avoiding the big probate fees that we have here in California. Most of us are not subject to estate tax at the current time because the exemptions are so high. California does not have an estate tax, and the federal estate tax limit states that we don't have to pay estate taxes unless we're worth over around $14 million. Most of us don't have that problem at all. So we're not too concerned with estate taxes, but we are concerned with probate fees because, as you saw with that one example, with the person who owned, let's say, a home worth $1 million and they had a loan against it, et cetera, their family, after they passed away, had to pay $46,000 to hire the attorney and to hire the personal representative to probate the estate, which may have just had one house in it. But those are the fees that we want to help families avoid. It's more of those California probate fees. Any other questions, folks?
Another question just came in.
Mm-hmm.
I heard some trust requiring EIN and the trust is tax exempt and transactions of the trust can be tax exempt.
Well, there are many different kinds of trusts. Some of them could be irrevocable, or some of them can be a charitable remainder trust. So there are many different types of trusts. They typically involve the principal, the person who's creating the trust, to give stuff away or have things out of their name because they just have too much. And they don't want to be subject to estate tax because they might be over the $14 million exemption, which is currently in effect. So these irrevocable trusts or charitable trusts, there are different rules that apply to them. Everyone needs this level of estate planning. the revocable trust, all of that. And then if they're, if they have a lot, yes, they might add on these other estate planning trust tools. We care about you guys. We want you to have control of your assets until you are no longer here. We want you to spend your money and save your money in the way that you wish. So we at HERA don't draft those types of trusts because our mission is to make sure to help California folks avoid probate and to make sure that an aging population is able to move into various stages of life with, grace and according to their terms, which are covered by the documents that we have discussed this evening.
Thanks, Kendra. And just one attendee with their
Sure.
hand raised, which we're going to turn on the microphone for them right now.
Go ahead if you have a question. Or if it's easier, you can pop it into the Q&A. Any other questions in the interim?
No, no questions coming in right now. Definitely feel free to email or call us if you had any more questions. But I think they're
Okay, great.
In case if I have any further question, how can I reach out to you guys?
Okay, can you see the slide that is still up on the presentation?
I just joined you guys
Okay.
late.
Okay, got it. So, are you more of an email person or do you want our phone number?
Email.
Okay, it's inquiries, INQUIRIES at HERACA.org. So
Okay.
inquiries at heraca.org.
Okay.
Okay. And
Thank you.
if you do write in, someone from our intake team will reach back out to you. They'll obtain some preliminary information. We are a nonprofit. And then if they think you're a suitable candidate for estate planning, they will schedule a meeting with one of the attorneys on our estate planning team.
Okay, thanks.
You're welcome. Any other questions?
another question.
Sure.
In the case of death, the trust becomes irrevocable,
Yes.
and the assigned executor of the if the original trust wants it, become the trust of the current executor.
I don't know if I understand what's happening, but what happens is when someone passes away, if they've created the trust and they name their successor trustee. So eldest child, Samantha, will be the trustee when I pass away. They pass away. Samantha needs to safeguard the assets, pay bills, pay final expenses, get the final tax return done. After those tasks have been completed, and the trustee knows what they have to do what the decedent has taken the time to say in the trust. So if everything's supposed to go 3 ways to Samantha and her 2 siblings, that's what she needs to do. She needs to prepare an accounting, say these are all the assets. This is what I sold the home for. These were the expenses. This is the bucket, and it's going 3 ways equally, or whatever the trust stated. So the trustee does not have discretion to decide to do something different. In fact, the trustee is a fiduciary to, in this case, the other beneficiaries, their siblings. Okay, they can't do extra things for themselves. If Samantha, as the first trustee, doesn't want to be the trustee, they would state that in writing. And then the second successor trustee would do what Samantha was supposed to do. Act as trustee, would need to do the same things. So that's why we always want a second choice if possible. They don't have a lot of discretion, but they need to do what the decedent has taken the time to say. in the trust. So in choosing a successor trustee, you want someone who's going to get things done, get the final taxes done. The choice for successor trustee does not need to be a financial guru or a tax expert or anything like that. They, of course, have the authority in your trust, typically, to hire an accountant as needed for the final tax return, to hire a realtor if a house is going to be sold, hire a lawyer if they need help, but oftentimes they don't need help. So they can hire people and they're not out of pocket anything in doing the trust administration properly. Hopefully that answers your question. If not, perhaps refine it in the chat or the Q&A.
Another question.
Mhm.
Can we establish for our children their own trust?
Good question. You can say in your trust that instead of having things go to kids immediately, that you want it to be held back and held in trust. So when that takes place, I, in general, think you probably don't want to hand a checkbook over to any child until maybe they're 25 or so. However, if you were to pass away and you were not able to help that child with college or medical expenses when they're under 18 or over 18, you would want your trustee to make sure to handle those expenses for that child. So in your trust, you can state, when I pass away, distribution will be in equal shares, and the money will be held in trust for the health, education, maintenance, and support of my kids until age 25 or 30. So that will give you peace of mind to make sure that your successor trustee will utilize the money to help your kids for the important things such as education and, living in a reasonable apartment, let's say in college, and having some kind of reasonable car or some type of transportation. However, the kids will not have the checkbook handed over at that time. The money would be held in trust for them until whatever age you decide upon. And you're the person who knows your kids the best, so you get to decide that age. It might be 25, it might be 30, it might be 10% at 25 and 25% at 30 and the rest at 35. Once again, keep it in mind that you would want the money to be used by your chosen successor trustee for the health, education, maintenance, and support of that child. So that's how you can create a trust situation for your child. You cannot create a trust outright for your child because a legal adult with capacity has to create their own trust. So you can't, and they have to sign their own trust. So you can't create a trust fresh for your eldest child who is 30 years old. They have to create their trust for their assets and choose who is an appropriate successor trustee and who might be a guardian for their minor children. And whatever they happen to have when they pass, they could decide where that goes. So you wouldn't be able to sign off on that trust for them, but you can within your trust kind of create a trust situation so that your kids don't have free reign until an age that you're comfortable with. And keep in mind, you can always change your mind too. So let's say right now you have young kids, and as the kids grow up and mature, let's say one of them just isn't maturing in the way that you would wish or anticipated, and they're 22 and they are not frugal at all, and they buy new cars and new things. So you can say, oh, instead of that money going to that child until 25, I'm going to do an amendment here. And the child will not know about it because you aren't have no obligation to share it with that child. It won't be shared until you pass away. But you can state, I think it's going to be held in trust until that child attains the age of 35. That's absolutely fine because once again, you can change the terms of your trust whenever you would like to do so, as long as you have capacity. Any other questions?
Definitely. Again, just really quickly, can we
problem.
explain more of what a trust is?
Sure. It's a document and it's going to have language which explains your family situation. So I have several kids and these are their legal names, their ages are this. It's also going to have language where if you have minor children, it's going to say, if I am to pass away, I want the guardian of my child to be my sister. It's going to have language that describes when I pass away, I want my assets, whatever they are. And you don't have to guarantee anyone a certain number or a certain asset, but whatever they happen to be when I pass away, they will be distributed to these kids in these proportions. And then the other part of this written document is going to say who you choose to do this for you one day when you're no longer here. You're going to name the successor trustee. You're going to name the second choice successor trustee. We always want to have a backup. The rest of the trust will just state, it'll have different clauses such as a no contest clause. So if any of my beneficiaries says when I passed away, gosh, mom promised me a lot more than my other siblings, and I'm going to contest this. I'm going to find a lawyer to do that. Well, if they really decide to proceed, they don't get anything. So we can have no contest language in there. We can have various things in there. So it's really just a legal document where you have language describing what you want to have happen one day with your estate, with your minor kids, and then who you want to be in charge of that process. It is a legal document.
No more questions. Thank you so much, Kendra.
Okay. All right. Well, thank you everyone for joining us this evening. Hopefully you learned a little bit. And thank you to Sonia and Afra. Thank you to Michael for setting all this up and helping with all of the technical parts of this, and to our interpreters. You guys have been great. We'll leave this screen on for a bit more in case anyone wants to take a picture or jot our info down, and we can sign off. Everyone have a good evening. Thanks again.
Thank you.
Thank you so much for holding this.
Thank you. Delighted to be here.
All right.